if they really wanted to enforce this language, particularly around being abusive, 95% of the comments that would exist on any site like this would be gone.
Welcome to the Contract Teardown Show from Law Insider, where legal experts tear down contracts from some of the most well-known companies and high-profile executives around the world.
In this episode, contracts attorney and legal industry commentator Colin Levy breaks down Boston.com's terms of service. Colin talks through how a drafting attorney balances educating online users with avoiding liability. Colin addresses the expectations of users, enforceability of terms, and policing of forums. Stumbling blocks abound with user-generated content, so let's tear it down. Hey everybody, welcome to the Contract Teardown Show from Law Insider. I'm Mike Whalen. On the show, we hang out with really smart people like my friend over here, Colin Levy, who tear down contracts. They tell us what they like, what they don't like. How are you today, Colin?
I'm well. How are you?
Pretty good. So guys, today the contract that we are talking through, the document that we're talking through is this. It's the terms of service from Boston.com, a news website, and we'll talk through sort of the structure of this, the big picture a little bit, but more getting into different clauses and the kind of language that is necessary and not necessary. So Colin, tell me about this particular document. When is a lawyer going to see it? Why does it matter? Why do they care to get this thing right?
Sure. So most, if not all, websites have a terms of use that essentially governs what users can and can't do on the site. This particular set of terms of use that we're going to go through today is for sites that offer usually a mix of kind of infotainment type stuff, so some news, some entertainment stuff, and a boatload of links to other sites.
Got it. And your background a little bit, I know that you're in-house and have been in-house. What's your background? What brings you to this particular site? Why is your brain wrapped up in the terms of service document?
So I operate my own blog. I have visited Boston.com as a site I frequently visit because it's just sort of a fun, newsy site for someone like me who's around Boston. My background is in contracts and in commercial transactions, so documents like this one are ones that are familiar to me. And I think it's important for users to recognize the fact that when they visit a website, by simply using the website, they're agreeing to these terms or terms like them.
Right. So this thing is written for consumers, right? It's on the website for consumers who are on there. It's one of those things that we all agree to, but we don't realize that we agreed to because we're just scrolling. So we'll talk about some of that and how, if you're the drafter, if you're the attorney in this case for Boston.com, how to keep Boston.com out of trouble and make sure that the users are also satisfied. Let's start with the very beginning. Let's start with the general rules and definitions. And in this, Colin talks about if you're choosing Boston.com or the different properties of Boston.com and any of the features, including but not limited to RSS, API, software, and other downloads, you'll be agreeing to abide by all the terms and conditions of these terms and services. What about this language? Do you like? What don't you like? What raises your cackles on this one?
So starting off, I think it's important to note that these terms apply not just to this Boston.com website, but to a whole bunch of other sites that you may or may not have been aware of that are part of the same ecosystem as listed here: bostonglobe.com, lawletters.boston.com, and realestate.boston.com. And sometimes those sites may not necessarily be described as separate sites, but they are nevertheless different sites as defined here. So that's something to be aware of. The other thing that I think is interesting here is it notes in the middle part of the paragraph that features of these sites, including not limited to RSS, API, software, or other downloads. Now, really what that's talking about is if you have this as part of kind of a aggregated news feed through RSS or through some other interface using an API, you have to abide by these terms as well. And not only do you have to abide by them, but also any users that get content through perhaps your aggregator that contains these Boston.com information, you also have to agree by these terms. So it's kind of broad. It's pretty typical, but it's something for certainly users to be aware of And for the, I would say for the drafter, it's important here to make sure that the language encompasses all that you want these terms to cover, right. Because it's important, and you want to make sure that those, if you own a whole bunch of different properties, but you want them to all abide by the same set of terms, it's important to note that at the outset. And I think, one thing that I think is that I can appreciate as a drafter is that this language is pretty straightforward as far as contract drafting language can go. So, evidently it is really kind of directed at readability for the user. Although when we go to other sections, I'll point out some things that are make it less so.
Well, and I was thinking about the real briar patch with some kind of content-driven website, a media website, is people, right? It's 2020. Everybody's super wound up. We just had this election, and everybody's at home being angry about whatever. In 3, they talk about user-generated content and a bunch of rules for how users should behave themselves. It's interesting because they do legalese, right? They talk about not uploading, anything libelous, defamatory, which I guarantee you, anyone commenting on the internet has no idea what those words mean because they use it wrong all the time, but nothing obscene, pornographic, abusive. But then it gets into like really common man language, use respectful language. Let's talk about the community. What about this? Do you think that the approach to legalese is better? Do you prefer the language that's talking to the average Joe? Should they both be in the same section? What do you think?
So that's a really interesting question. I tend to be of someone who appreciates using plain language. So sort of the Ken Adams style of contract drafting. Right. So I think that the second paragraph here is useful. I think it kind of has a human quality to it, and I think that is something that is useful. With regards to the first paragraph, I mean, I think we all get it that when you or on a website and you're allowed to comment, you may not agree with something else that's said and feel the need to want to be more aggressive or more critical of what is said. So, they're saying that you shouldn't be defamatory, obscene, abusive, but I will guarantee, and I don't guarantee anything, that there are definite instances on sites like Boston.com and others where that is definitely the case, which is to say that though they do put this in and say you cannot do this, as to whether they actually enforce that or not, it's a little bit of an open question because I think there is a degree of moderation that's involved, but at the same time, if they really wanted to enforce this language, particularly around being abusive, 95% of the comments that would exist on any site like this would be gone.
Right. There'd be no more comments anymore. And they continue in that section to say debate, but don't attack. And then, talk about, again, the value of community and discussion. But then, again, there's, it says if your attack contains a threat of violence or may incite violence, we're going to report you. And there was a case I heard about recently that the FBI they did this, right? There was a media site that a guy went on and he talked about death threats for the supporters of the candidate on the other side. And, the FBI is going after them. They also point out that you can't impersonate another user or a Boston.com staff member by using a similar screen name. And then this sentence, which I don't even know what this means, you must disclose conflicts of interest.
So there's a lot to be said here. I think, first of all, around the debating, don't attack, I mean,
good luck.
Okay, that's a nice thing to say, but that's not going to be the case.
Right.
However, certainly, especially in this type of, superheated environment, violence, threats to incite violence, a direct threat to someone else that I'm going to, burn down your house at this address and beat you to a pulp or whatever. Yeah, that will definitely, definitely would spark not just moderation in terms of removing the comment, but from the investigation, because, exposure of people's information and or a direct threat against someone that seems actionable is something that would want to be investigated. That being said, I think there's a lot of leeway that they have put in here with regards to, how strictly they're going to enforce it.
Well,
you know,
and I wanted to ask you on that. I'm assuming that that kind of liability for threats exists whether Boston.com wrote this thing or not, right? So maybe it's more about notice than it is about creating some kind of right for them to go and do this thing. And with that, I sort of feel like if somebody were to engage in this kind of behavior, does it create a responsibility on Boston.com to go report these things? Like, maybe this language is a bit evasive because otherwise Boston.com is saying, we got this. We'll be the police of the internet threats.
That's exactly right. So, you know, there's a line when you're drafting any type of agreement between specificity and vagueness. And sometimes being vague can help you and sometimes it can hurt you. In this case, it helps because they're saying, you know, debate, don't attack. If your attack contains a threat of violence or may incite violence, we may report it. It doesn't say they will report it. It also doesn't define exactly what that threat of violence may be or what exactly qualifies as inciting violence. So it's kind of leaving the door open saying, all right, well, we're going to be looking at what you're saying. We may do something about it, but we're not putting any onus on us to do so. So they're kind of getting themselves out of being directly liable for that type of behavior,
right,
but at the same time protecting themselves by saying, yeah, you know, we're going to be doing our best, but our best may not always be good enough. And that's a smart move on their part. You know, that kind of protects them against unwarranted, you know, I would say degrees of liability on their part, but at the same time, does alert users that there is a line. It just doesn't define what that line is.
Right. So don't be a jerk, but don't call us if somebody else was a jerk to you. That seems to be... Any idea what that last line is about the conflicts of interest thing? I mean, do we really expect people in comments to be like, I hate this other candidate, but just as a side note, I voted for so-and-so in 20, and I really like puppies, and this guy has dogs. And you know what I mean? How far do users have some affirmative duty? Nobody's reading this thing anyway. You know, very few people are reading this anyway. What is that line about? Do you have any idea?
So that's a very interesting line. I think I don't honestly know what sort of the intent behind it, at least with regards to Boston.com, but in general, as an informed, you know, user and a lawyer reading that line, I think that, you know, if you're trying to, you know, perhaps if you're an employee of Boston.com and you're going on there and bashing your own company, or if you are, you know, working directly for someone's campaign and bashing the other candidate, on a forum like this, they don't want that to happen. And so I think that's kind of what they're trying to say here. But again, them saying you must disclose conflicts of interest without actually saying what would happen if you don't is basically saying, well, all right, we want you to be transparent, but only to a degree.
Yeah, it feels a little bit like version 2.5 didn't have that sentence, and then somebody did something stupid, and so version 2.6 has it, and nobody can really. That is the life of contracts.
I think that's exactly right. I mean, it's not the best drafting. At the same time, they also probably, you know, readily acknowledge implicitly that not everyone's going to be reading this. In fact, the only people probably reading it today are probably you and I.
Hey everybody, I'm Mike Whalen. I hope you're enjoying this episode of the Contract Teardown Show. Real quick, I want to ask you to do me/you really a quick favor. Look down below. You'll see a discount code to join the Law Insider Premium subscription. When you do that, you get access to more content like this. You'll see webinars, daily tips on contract drafting, not to mention access to the world's largest database of sample contracts and clauses. It will help you write better contracts faster. If you want to do it right now, there's a code below, so get there. Also, if you're part of a larger team, if you're in-house or in a law firm, just email us. We're at sales@lawinsider.com. We'll make sure you get a deal as well. Come join us in the community. The code is below. Let's get back to the show. Well, let's go on and talk about something that you mentioned before, which is this access and availability of services and links. The fact that this site is embedded in the World Wide Web. I mean, they literally say in 4.1, the services contain links to other related World Wide Web internet sites, which is like a sentence I haven't heard since the 90s. Tell me about this section. What about this is triggering you on this one?
So, number one, I think it's odd and interesting that they would directly literally write out World Wide Web internet sites, because internet and World Wide Web essentially are the same thing. So, I mean, redundancy has never been, has never been knocked against by lawyers.
We used to get paid by the word. Redundancy is a win, man.
Here it just seems just awkwardly drafted and just odd. The second part I would say that I think is important is basically they're just essentially disclaiming all liability for any of the sites that are linked to through Boston.com. So, it could be anything, and if that site somehow contains information that you find offensive, or has malware on it and hurts your computer, or anything between those two scenarios, they're not responsible. You need to go after that other website. So, which brings me back to kind of what the first part we went over in 1.1 about them specifically listing their properties. So that comes into play here, because they're basically saying, all right, well, here are the properties we are going to be responsible for, but anything else we're not going to be responsible for.
So that provision was inclusive. This one's exclusive. I wonder if this gives them the ability to, I'm thinking about if they do a report on some white supremacist dark interwebs corner, if they put a link into that, does that give them the ability to say, yeah, we don't know who these people are? And, then you start getting into, is that responsible journalism? Is this ethical? But at least if I'm the contract drafter, it sounds like I want to give the employees the freedom to do whatever the heck they want to in terms of assuming liability. Let somebody sort that stuff out later if we want to get in trouble, if we end up getting in trouble.
Yeah, so it's kind of basically just saying, all right, well, we got these other sites. Whatever they choose to do on those sites, that's between you and that other site's problem. It's not our problem. We're linking to it, for any number of reasons, but those reasons are irrelevant to the fact that we're not responsible for what we're linking to.
Well, let's go to the representations and warranties. This is Section 5, and looking at 5.1, it's giving the consumer this duty that you are representing, warranting, and covenanting that basically you don't break any of the rules that we talked about before. You don't, plagiarize, infringe upon the rights of a third party. And if you do that stuff, you're indemnifying and holding harmless Boston.com and all the officers for all the information put out there. Talk to me about this. I'm wondering if this is effective in a situation where somebody has a comment section and they're empowering people to go put all of this infringing material on there. Can they really, with this, just let it go? I'm wondering how effective this indemnification is.
So that's a really good question. I would be hard-pressed to name a specific example where something like this was actually enforced in a court of law. However, I think that essentially what they're going after is saying that, say all that you want, but don't specifically kind of name, anything or use someone's trademark or whatever in a way that would hurt their company or their brand name. And the likelihood of anyone doing that would be very low anyway, because these big companies, you're a single person, and these big companies have teams of lawyers that are specifically devoting to protecting their IP. So there's that. The other thing that I think is interesting to note here is this indemnification, where basically they're saying that should anyone sue us because of your violating of these terms, as asserted by a third party, you're going to essentially, protect us against that suit. However, if we, don't want or don't like how you're doing it, we'll take over the defense in control of any indemnification at our at our discretion. So that's kind of interesting in the sense that they can do that. It's not uncommon, but I think what's important for kind of the user to note that is them doing that could be potentially costly for you, because you're the one who has to pay for that cost, not them. They can, participate in it to their own, and pay for it at their expense, but there's still some degree of liability on your part. So it's sort of interesting. I don't think it's fairly common for them to have that in here, but again, I don't think it's that. It doesn't get enforced that often.
And continuing in the representations and warranties, I'm looking at 5.2. There's a lot of capital letters in there, which is always helpful. But they're basically saying we don't endorse the accuracy or reliability of anything that a user posts on here. Again, repeating what they've said before, that we're allowing people to have a forum, but this isn't us. You know, they're trying to claim this platform benefit while not being a platform because they're a media company. And then there's all kinds of stuff in capital letters about it being as-is basis, no warranties, express or implied. Do you like this section? Do you think this works?
So they're really doing two things here, and I don't particularly love the way that they've done it here because they're doing two things. They're basically saying that we don't represent or warrant, you know, what they list there, but at the same time, and they're also kind of disclaiming a whole bunch of things, and that's why everything is in capital letters, because legally you have to kind of call out that kind of disclaimer. But I think it's confusing in the sense that it's under reps and warranties, but there's no kind of language stating that this is actually a disclaimer. So it's a little bit confusing. And if I were drafting it personally, what I would do is, you know, under 5, you know, after 5.2, where it begins with the capital letters, I would actually make that a separate paragraph and say, you know, disclaimer, and here's what we're disclaiming. Basically, you're using this as is, and, you know, we're not, you know, warranting anything other than what we have already said in this paragraph, which is basically nothing. So I think that's important to note here. They kind of, you know, mash two sections together here, which is fine and not altogether necessarily uncommon, but at the same time, me being someone who tends to like things a little more organized and delineated, I think that it would be probably serve for readability and ease of following purposes to separate it out a little bit.
Yeah, and I'm thinking about... Sorry, go ahead, Colin.
Oh, I was just going to go back to 5.1 and just correct something that I had said, which is that under the indemnification, it's actually kind of interesting that they note that actually their right to assume the defense is at their own expense, meaning that if they don't like the way that you're defending it, they'll step in and pay for it themselves, which is somewhat unusual, actually, because usually in indemnification, no matter what happens, the person who has to indemnify is the one who has to pay. So here they're saying, well, if we don't like what you're doing, we're gonna take it over and we'll pay for it. Which again points to the fact that it's likely not that in use that often, because if this were something that came up all the time, it would be very, very expensive.
There'd be no Boston.com anymore. Yeah. Well, and it's straddling this really interesting issue in this moment where, you know, media companies are trying to figure out what kind of protections they have versus what they need to take responsibility for. And for that, you know, I'm kind of thinking of general principles, and I want to get your feeling on this. On the interwebs, the World Wide Web Internet, I think is what they called it, you know, there's a lot of media production, and it seems like the holy grail in Web 3.0 or whatever we're at, that you want a lot of that production to come from users. But there's an issue with that users can be crazy, and they're not under your thumb. You don't have control over them. So you've got this kind of weird relationship. If I'm drafting, if I'm an attorney and I'm dealing with a modern media property or somebody operating on the web with user-generated content, what kind of principles can I draw from this example that we've given today?
So a couple of the principles I would outline would be, number one is ensure that you are, you know, expressing some interest in what is posted on a website and that you'll be watching it. But at the same time, you can't control everyone. And so therefore, you know, there's some, you know, the onus really is on the commentators to, you know, watch what they say. Right. So that would be one principle. Another would be if you are linking to other sites, to make sure that you're not taking more liability and responsibility than you should. Meaning that if you're linking to another site, that in your terms you're saying, well, I'm responsible for what's on my site, but on someone else's site, that's not my problem.
Right.
So those would be a couple principles, and then a third principle probably would be just, these terms aren't really read by anyone that often, and they're certainly not enforced that often in court. But just because that may be the case doesn't mean that you should be lazy in how you draft them.
Yeah, that might come up in a court case if it ever came up. And I'm thinking about the kid recently who went through the lawsuits where they're apparently suing every media company in the world for the reporting on him standing in front of the Native American man banging on the drum. Whether these lawsuits actually succeed or not is sort of not the question. If these media companies are wrapped up in these long-term suits, they're paying out money either way, whether in defending or and it's such a nebulous area that these documents can help protect. So I appreciate you going through it. Colin, if people want to reach out to you and maybe talk more about what you do and talk more about documents like this, what's the best way to get in touch with you?
Sure. So 2 ways. One is on Twitter at clevy_law or ColinSLevy.com.
Awesome. And everybody who's watching, I appreciate you being here for the Contract Teardown Show. You can find information on this and other videos that we've created at lawinsider.com/resources. If you want to be a contributor on the Teardown Show, just reach out to us. We're at community@lawinsider.com. We'll see you guys next time. Thanks again, Colin.
Thanks.